Hello and welcome to a Matter of Fraud podcast. I'm your host, Ashley Ferguson, Associate Lawyer at Investigations Counsel. This podcast is brought to you by Investigations Counsel, fraud recovery lawyers. A brief disclaimer for our audience. Although we talk about fraud law and fraud adjacent topics on this podcast is not legal advice. If you have been or think you have been the victim of fraud, please contact a fraud recovery lawyer as soon as possible to preserve your rights. Welcome back to episode 2 of a Matter of Fraud podcast. In this episode, we will focus on an important legal topic that all fraud victims should be aware of, and that is the issue of limitation periods. I am again joined by Norman Groot, principal here at Investigations Counsel, who has lots of experience with limitation period issues, right?
That's right. Mostly positive, a few negative, but mostly positive.
So that's good. Today we will discuss, first of all, what the limitation period is, an overview of the law surrounding limitation period issues, and generally what fraud victims should know about limitation period issues and issues like criminal complaints, bankruptcy proceedings, and other pitfalls. And then finally, we will end on some really fun real-world examples of limitation period issues from our own personal experience and from the case law to help potential victims understand the limitation period issue. Before we begin, I just want to stress that this topic is hugely important and complicated. So if you or someone you know thinks that you have been the victim of fraud, you should always seek legal advice from an experienced fraud recovery lawyer. And the reason for that, as we'll get into more detail on this topic, is if you miss the limitation period issue in Ontario, you will be prevented from bringing a lawsuit against an individual or business to recover your money. So it's hugely important to be aware of this topic and to be diligent about seeking legal advice about it. Also on that note, our discussion today is focused on the jurisdiction of the province of Ontario in Canada. So if you are located in a different jurisdiction, the general concepts might be relevant, but you probably want to seek out a fraud recovery lawyer in your specific jurisdiction. We discuss a general topic today for general knowledge purposes. So I'm just trying to keep it high level without too much legalese. And for a more detailed analysis, we will link in the show notes to our website, which has really great detailed blog posts on this specific issue. So with that, let's get started. Our discussion today is about the applicable limitation period to civil fraud cases in Ontario. So the first question, what is a limitation period issue? A limitation period is a period within which a legal proceeding must be commenced. Failure to commence a legal proceeding within a limitation period, or as we often refer to it, missing the limitation period, may result in a bar from bringing a legal proceeding. The limitation period in Ontario is set by the legislature via something called the Limitations Act. And the Limitations Act sets out the applicable limitation period to civil disputes, most civil disputes in Ontario. For our purposes, like I said, we're discussing the limitation period applicable to civil fraud cases in Ontario. And for that, there's a basic 2-year limitation period for civil fraud disputes in Ontario. So you want to make sure that you're keeping that date in mind. It's pretty simple, 2 years.
From the date of discovery.
From the date of discovery. That's an important qualifier. So more specifically, the Limitations Period Act requires that civil lawsuits must be commenced within 2 years of the date on which a claim is said to have been, quote unquote, discovered. And I use quotes there because what we mean when we say discovery is a very specific definition under the Limitations Act and under the applicable case law that surrounds the Limitations Act. So the issue of discovery, or what the concept of discovery is also described in the Limitations Act. And so I'm going to read directly from Section 5 of the Limitations Act here, so we get a general understanding of what discovery means. So the Limitations Act states that a claim is discovered on the earlier of A, the day on which the person with the claim first knew, 1, that injury, loss, or damage had occurred, 2, that the injury, loss, or damage was caused by or contributed to by an act or omission, and 3, that the act or omission was that of a person against whom the claim is made, and 4, that having regard to the nature of the injury, loss, or damage, a proceeding would be an appropriate means to seek to remedy it. So that's the first qualifier.
Should we explain that in plain language?
We sure can.
Plain language means if you realize you've been ripped off and you know who ripped you off, that's your discovery date.
Right. So that's in the very clear-cut case where you know what's happened and you know who the person is who's taken your money or made the misrepresentations to you.
That's right.
Fraud case.
You don't have to worry about how much the loss is. It's just when you realize you've had a loss or incurred a loss and you know who did it.
Right. And under Section 5, sub B, there's a second qualifier, and this states that the limitation period is discovered on the day on which a reasonable person with the abilities and in the circumstances of the person with the claim first ought to have known of the matters referred to in Clause A. So this is what we refer to as sort of the reasonable diligence requirement for individuals who maybe think that they have suffered a loss. The Limitations Act says that they have to make themselves aware of certain things, like whether a loss has occurred. Now, if that legal language sounds a bit vague and complicated, that's because it is. And there's a whole kind of robust body of case law, judicial analysis, etc., that has developed around specifically this concept of discoverability. So while it is straightforward in some aspects, like most things in law, we lawyers tend to make it kind of complicated. So the issue of discoverability is also, debated in courts in Ontario every day. So again, therefore, if you suspect that you or someone you know has been the victim of fraud, the most important thing you can do is seek legal advice from a fraud recovery lawyer to make sure that you take appropriate steps to preserve your rights, especially regarding the issue of limitation periods. So the next thing I want to touch on briefly is the issue of that discoverability question, specifically as it pertains to fraud cases. So we often describe fraud here as theft by lies, which we call those lies misrepresentations. So fraud often involves, or always involves, an element of dishonesty, with the victim not knowing the full truth about the state of affairs. And that's because the victim has been told something different by way of the misrepresentation. So the discovery date in fraud cases is not the same date that either the misrepresentation was made or that you or a victim of fraud transferred their money to the fraudster on the basis of that misrepresentation. And the reason why that discovery date is not often that date is because the fraudster has a vested interest in concealing the nature or the fraudulent nature of their scheme. So concealment of the scheme is usually used by fraudsters by continuing misrepresentations, by providing fraudulent documents to conceal the fraud or the true state of affairs, and by taking other actions to prevent the victim from learning that they have been scammed. This podcast is brought to you by Investigation Counsel, fraud recovery lawyers. Okay, so at this point, I'd just like to bring Norm in. So, on the issue of discoverability, as we've said, it's a complicated issue. What do you think is the most important thing, or one of the most important things for fraud victims to know about the issue of discoverability as it pertains to limitation period issues?
So the most important thing for any fraud victim to understand is they probably don't even understand they're a victim at the time. They may suspect that something's wrong. They may often wish to believe that nothing actually is wrong, but still something bothers them such that they talk to friends or relatives or someone they respect and eventually get referred to a lawyer. If that's happening, that raises the question of discoverability, because discoverability on a legal standard is objective. That's what a reasonable person would be on notice that something's wrong. So as you mentioned, the real limitation date starts from the date of the wrongful act, the date of the lies in order to obtain your money. And in any good fraud scheme, those lies are concealed. So it often takes a while before you figure out that, hey, I might have been ripped off. In an investment scenario, there's a due date by which money should be paid out. Or if there isn't, you're asking for reports or when you can cash out. And you're getting excuses. And the more excuses you hear, the more you get suspicious. Objectively, that is when you should be making inquiries with a professional. That is when, if you sue the fraudster down the road, the fraudster is going to defend and say, you knew something was wrong. You should have sued me within 2 years. You didn't sue me within 2 years. I'm free to go. Ridiculous, but true.
Right. And that kind of goes into the degree of knowledge that's required for a claimant or a fraud victim to have in order to say that you've discovered a claim. So you don't have to know all facts. You don't have to have a complete understanding of the fraud, but there should be some material facts that you know that maybe would cause concern or raise the red flag in the fraud victim. So basically what we're saying is that if somebody suspects they have been a victim of fraud and they might know 1 or 2 facts that raise the alarm bells, that could be considered sufficient by the court to say that you had discovered your loss.
Right.
And that's full understanding.
That's why people ask us to make inquiries on their behalf or just to run their scenario by us. And we can tell them based on our experience dealing with lots of cases, whether they likely are and they should be making more inquiries. So we just recently had that with an American fellow who thought he was getting an inheritance from what he thought was a Canadian lawyer. And when he told us his scenario, we told him he was likely a victim of fraud based on other cases we know about. And then, most importantly, is we brought a tracing application to see what happened to his money. And that confirmed that the fraud actually took place. So it's from the date that he should have been put on notice or be aware that the clock starts to tick. And in that fellow's case, he really may have limitation issues simply because it took an awful lot for him to realize that he should be asking a question. So one thing you'd want to avoid to the extent that you can is getting into litigation about discovery dates. There's no benefit to waiting.
Right.
You should act upon it immediately.
Right.
And then what you're going to get into next is reasons why people often don't act.
Right. Yes, that is our next topic. So I'll just wrap up this issue of discoverability, with a statement that suspicion of certain facts of a potential claim may be enough to put a plaintiff on inquiry and trigger the due diligence requirement to investigate further, ultimately leading to a determination that they have or should have discovered their loss. And that can lead into missing of the limitation period. So, Norm, if you could help explain to us what are sort of the important issues or pitfalls that all fraud victims should know about limitation periods, and issues like criminal complaints and the bankruptcy system.
Right. So the most frequent limitation date issues arise from people who are victims who believe that they are protecting themselves simply by filing a criminal complaint or simply by filing a proof of claim in a bankruptcy. The other pitfall, if you want to call it that, is people who simply refuse to accept that they may have been a victim of fraud. And sometimes it's pride, sometimes it's ego, sometimes it's just naivety. But the main problem is people who believe that the criminal system will protect their interests. So the criminal system, and we're not here to slag the criminal system, but it is unreliable. So you can file a complaint with the police depending on the jurisdiction and the urgency that the police view the complaint in. It's not uncommon. It is quite common that fraud complaints are not investigated for a year, even more than 2 years from the time the complaint is made. So you're basically statute barred from the get-go if that's what happens. If the police actually do commence a timely investigation and a criminal charge is laid, there's no guarantee that the Crown will actually prosecute it. The Crown may withdraw the charge. The defense may bring a charter application or some sort of other defense. The fraud complaint may never result in a conviction. Even if the criminal process was successful in the sense that a conviction was issued, it's discretionary upon a court to issue a restitution order. Meanwhile, while all this criminal process is going on, the more time that goes by, the more risk that the victim's money is being dissipated. Money should be, in most every ideal case, traced and preserved through Maria injunctions at the earliest opportunity. And if the fraud victim doesn't want to prosecute their civil case zealously because they filed a criminal complaint, then it's at that point that the civil case can be put on the shelf, put on hold to see what happens with the criminal process. But simply waiting for the criminal process to work its way through often leaves victims with no recovery route once the criminal process is over with. And that's especially true in large Ponzi schemes where even if there are convictions, the courts don't want to issue restitution orders because it's too messy to figure out.
Right. So in that sense, the criminal system is great and it provides another important thing in society, which is, punishment and deterrence and all those things. But the criminal system is not specifically interested in pursuing the recovery of money for fraud victims. They kind of have their own purpose in society.
The other problem with the criminal process is that it's often narrow in scope. So they're only going to be suing the fraudster, but not tracing the money to the point where it can be preserved in the hands of some third party, the conspirator, that sort of thing.
Right.
So in this one bookkeeper case we have, for example, we sued and got judgment against the bookkeeper. She really didn't have assets. We said, go ahead, file a criminal complaint to our client. But the important thing is that we now then went after family members who benefited from the fraud and brought fraudulent conveyance actions to unwind transactions, that sort of thing. Criminal process won't do that for you.
Right. Yeah. And so fraud victims, if they're hoping to gain a recovery through the criminal process, if they wait throughout that whole process, number one, the criminal process can fall apart at what you mentioned is basically three different portions. So it could fall apart at the investigation stage, it could fall apart at the prosecution stage, and it can fall apart post-conviction by the failure to issue a restitution order. And so in that case, if a fraud victim were to wait for that whole process to go through, they will probably have ended up missing their limitation period on the civil standard.
Yeah.
And what about in the bankruptcy context?
So, bankruptcy, the filing of a bankruptcy, either the fraudster getting assigned into bankruptcy or assigning him or herself into bankruptcy, would result in a stay of any civil proceeding. But if a civil proceeding hasn't been commenced and you just file a proof of loss or a proof of claim in a bankruptcy process, sometimes the bankruptcy process can take more than 2 years to unfold. With most first-time bankrupts, they are automatically discharged after 9 months. And so there is a reasonable prospect that the limitation date will not expire. There won't be a problem. But in complex frauds, especially like Ponzi schemes, for example, this Plutowski scheme that's going on right now, the discovery date is right at the 2-year mark now. The trustee has brought an application to oppose discharge. And so to the extent that people want to have a civil claim issued to recover what the trustee doesn't at some future date down the road, they have to file their civil claims now. And it means that they have to bring an application to the bankruptcy court to lift the stay of proceedings that otherwise the Bankruptcy Insolvency Act would impose.
Right. Yeah, so that's an important thing for fraud victims to know when the fraudster has been assigned into bankruptcy, that period of time when the fraudster is in bankruptcy, your limitation period is running. So make sure that you talk to a fraud recovery lawyer to preserve your rights. So now to a fun part, I think. We'll see how fun you think it is. I want to do some real world examples of specific fraud cases of assessing the limitation period. So to help the listeners and viewers maybe understand this topic more, or maybe, self-assess to a certain extent, an applicable limitation period. And so these examples, they come from our work here at Investigation Counsel and the case law. So I'm going to pose the question and then we'll have a little bit of a discussion. See if you get the answer right.
All right.
So example number 1, you are a business owner. You hired your bookkeeper, Donna, in 2019. As part of her role, Donna had access to your corporate bank account via online banking to monitor payments received and made by the business. On December 1st, 2023, you discovered that Donna had been sending e-transfer payments from your corporate bank account to her personal email and depositing them into her personal bank account. Donna was disguising the e-transfers as HST payments in your accounting software. The first fraudulent e-transfer sent by Donna was on July 5th, 2020. In total, across over 4 years, Donna has stolen $200,000 from the company. So Norm, what is the applicable limitation period for you as the business owner, to commence a civil fraud lawsuit to try and recover the $200,000 stolen by the bookkeeper, Donna?
The reasonable discovery date would be December 2023,
Right.
because the fraud was concealed by way of these alleged HST payments. And especially a case like this, the victim company should be moving to freeze their bookkeeper's assets right away. They shouldn't wait. They shouldn't file a criminal complaint. That can all be done later. But if they want to try to settle the case themselves, again, I wouldn't recommend this. But if they wanted to do that, or attempted to do that, they would have till approximately November of 2025 to issue their claim.
Right.
And with respect to that particular case, we are aware that that particular bookkeeper had been ripping off a prior employer for years, and for a lot more money. And then that company entered into a private settlement without litigating, for pennies on the dollar. But the funds stolen in the second fraud were actually used to pay down the settlement in the first fraud. So the bottom line is that sue right or get legal counsel right away. See if there's assets you can trace and freeze. In some of these bookkeeper frauds, we've made full recoveries. In other ones, there's marginal recoveries.
Yeah.
But you never know until you go after the person's assets through their banking and otherwise to know.
Yeah. Especially in the bookkeeper cases, the ones that I've worked on, at least, they kind of go into two buckets. There's either the funds were used for real assets, property, to pay mortgages, etc., or unfortunately they were used for a gambling or other sort of addiction. In that case, they're pretty much gone. But in the former case, you could look to those real assets to maybe recover. So in this scenario, if the business owner did report the complaint to the police and Donna was arrested and charged, would that have any effect on the limitation period for the civil action?
Well, it would not stop the clicking or the running of the limitation period. So it would not be, it's fine to file a criminal complaint in those circumstances, but not till after you preserve the assets, and don't think you're going to sue after the criminal process has run its course.
Right. Okay, so you got that one right. So now we'll go on to number 2. And this one is a little more interesting. So you have agreed to provide $100,000 to your friend Brian to invest in cryptocurrency on your behalf. Brian told you to transfer your funds to his personal bank account, and he would use your money to exchange and buy specific cryptocurrencies to hold as an investment in his cryptocurrency wallet. Brian told you many things about his experience as a cryptocurrency trader and promised that with his guidance, Brian would help you make a substantial profit on your $100,000 investment with very little risk. Brian promised you that he would send you monthly statements that showed how much your cryptocurrency investments were worth. You transferred your money to Brian on March 29th, 2024. On April 30th, 2024, Brian sent you a monthly statement. According to the statement, your cryptocurrency investment had grown in value by $10,000 already. Congratulations.
Thank you.
On May 31st, 2024, Brian sent you a second monthly statement. According to that statement, your cryptocurrency investments had grown in value by $20,000. However, Brian stopped sending you the monthly statements. In fact, Brian stopped communicating with you at all. You sent Brian emails and text messages asking for an update on your investments. And on July 5th, 2024, to your shock and horror, Brian sent you an email that said he never invested your funds in cryptocurrencies at all, but rather used the funds to buy himself a new Lamborghini. Brian said in the email that you had in fact owed him that money, and therefore he wouldn't be paying you back. Brian told you to stop contacting him. What is the applicable limitation period for you to commence a civil fraud recovery lawsuit to recover the $100,000 stolen by Brian and used to buy his Lamborghini?
Well, in that scenario, there again is no benefit to holding back. You can make a legal demand. You can issue an action if you wish. You could try to see if a court will issue a Marie injunction and have your money traced and preserved. But to avoid a discovery issue, I would not wait 2 years from the date he tells you that he put the money into a Lamborghini. From the time he stopped communicating with you, stopped sending you reports, that raises flags about whether you should objectively been realizing that you had a loss. So to avoid any of that sort of dispute, issue well in advance of that 2-year mark.
Right. That's great advice. Don't try to figure out yourself whether the limitation date was the date that he stopped sending you the statements, or was it the date that he told you that he put it into a Lamborghini. Just act as diligently as possible and preserve your rights. So would your analysis change if Brian, say, assigned himself into bankruptcy and told you, you're not going to get me because I'm now a bankrupt?
Well, that it raises the question of throwing good money after bad. So on an investment of $200,000, sometimes it's hard to justify asking a court to issue a Marie injunction. Bringing these sort of motions can be expensive. Plus, you have to get a court to issue an order to lift a bankruptcy stay. So if you do not believe, if you didn't want to bet on the hope that you'd actually be preserving an asset by bringing an asset freezing injunction, and that you just want to issue a claim so that hopefully one day in the future you could possibly recover if this guy ever came back into assets, then you could let the bankruptcy process run its course. Be mindful of when the discharge date is, monitor it, and issue a claim once he's out of bankruptcy. Now, it raises other issues as well. Your claim would have to contain what's called a Section 178 declaration, meaning that the claim would survive his bankruptcy, because of course the idea with a bankruptcy is that it washes away all debts. And I suspect that Brian may list his debt to you in his bankruptcy, claiming it was just a contract and there was no fraud.
Right. Yeah, and you want to always be mindful of what happened to that Lamborghini.
That's right, the alleged Lamborghini.
Yeah.
Because they can show up months or years later,
yeah.
as we know.
And they can disappear sometimes too. Okay, so last example. This one's a bit long, but I think it's important because it's going to exemplify this issue of reasonable diligence for discovering your loss. Okay, so example number 3. In early 2020, you invested $1 million in a joint partnership with Dean to purchase a residential property, renovate the property, and sell it in the hopes of making a profit. This is otherwise referred to as house flipping. You and Dean agreed that your $1 million investment and another $1 million to be invested by Dean would fully fund the purchase of the property and renovation expenses. Then, when the property was sold, you and Dean would split the proceeds 50-50. You and Dean opened a specific joint bank account, and each of you deposited your funds into the account. On January 15th, 2020, the transaction to purchase the property to be flipped closed. Property was purchased in Dean's name personally, but the funds came from the designated joint bank account. Throughout 2020 to 2022, the property was renovated. In April 2022, the property was listed for sale and sold for $3 million, so he made a good profit. The sale transaction closed on May 1st, 2022. You were busy that day, so Dean handled the sale with the real estate agents and lawyers. Shortly after the transaction closed, you asked Dean about your 50-50 share of the proceeds. Dean told you that there was some delay in receiving the sale proceeds from the purchaser, but assured you that you would be getting the money soon. In October 2022, you asked Dean about the sale proceeds. He did not respond to you for several weeks, but when he did, he told you that he had simply quit his job as a used car salesman. In January 2023, still without receipt of the proceeds, you called the lawyer who completed the house transaction. The lawyer told you that he could not tell you anything because you were not on title to the property and he was not aware of your partnership with Dean. In August 2023, you again asked Dean about where the sale proceeds were. Dean told you that he was working on an accounting of the funds. But this was surprising to you because there shouldn't be an accounting issue as the agreement was a simple 50-50 split. In April 2024, Dean called you and told you that he had completed the accounting and would be sending you the proceeds by no later than the end of May 2024. You were happy that you would get some money, but still concerned as to why it took so long. However, Dean did not end up sending you any money. In July 2024, you finally asked the bank for copies of the joint account statements and discovered that on May 1st, 2022, the sale proceeds of $3 million were deposited into the joint bank account. On May 2nd, $2.9 million was withdrawn from the account and transferred to an unknown account. There remained less than $10,000 in the account. You frantically tried to call Dean, but you discovered that his phone had been disconnected. You looked at Dean's Instagram, and the last picture he posted was over a year ago on a boat in St. Lucia with thousands of dollars of cash in his hands. It is now July 5th, 2024. Have you missed your limitation period to commence an action against Dean?
I'm going to say no.
Oh.
However, once you started questioning where the money was and the money wasn't paid out, that objectively is when the limitation period should start ticking. So in that scenario, I wasn't quite clear on what that date was, and that's why I say you haven't missed. But I do recall this case scenario, and that was one of those cases where we did recommend that the complainant immediately moved to freeze the accounts and trace the money. And although the money had been dissipated, the inconvenience that a Mariva injunction would put on that particular bandit resulted in him finding sufficient resources from elsewhere and settling that case relatively quickly. Which just all goes to the point of there is really no benefit to waiting.
Right. Yeah. So in that case, I mean, in this example, it is a bit unclear because while you did have access to the bank accounts because it was a joint account, there was some concealment by means of representations about an outstanding accounting and that the money would be coming soon. So that's an unclear case. And in a similar real world example, but for that kind of unclear issue, we moved right away and were able to kind of get a good result, actually a great result for the clients on that. So just in general, what does this example kind of tell us, or what can we take from this example about the concept of reasonable diligence and discoverability? I think you mentioned it already, which was there's no benefit in waiting. Once you know some suspicious facts, really you should contact a fraud recovery lawyer and start your investigation as soon as possible.
Absolutely.
Okay, and I just want to end on the issue of, possible risks to victims of fraud by not diligently protecting their limitation period issue. And that is that if you do start a claim, the fraudster can bring a summary judgment motion and seek to have the claim struck as against the limitation period. That's called a limitations defense. And if they are successful in that case, you may have to pay the fraudster's legal costs, which is to be avoided at all costs.
Yeah, that would be heaping injustice on top of your financial pain. And I guess just another caution that's out there, if you're dealing with somebody who's died, then the discovery period even becomes more tenuous. So there's a hard line on suing anyone who's died within 2 years from the date of death,
Right.
unless you can show some sort of special relationship and fraudulent concealment. But when someone dies, yes, it's best to act quickly.
Right. Yeah, that's right. And there are various other sources of limitation periods in Ontario, not just the Limitations Act that I referred to at the beginning. So you want to make sure that you're looking to the specific statute or case law that applies to your specific case. So in that case where it involves a deceased person, there's a hard date from, I think that's the Trustees Act.
Yes.
Yeah, so that's a different act that applies, but that all goes back to our kind of main point that we're going to put in flashing lights for this episode is get legal advice, because it is a hard bar if you miss that limitation period.
Yes, and the risk of these cost orders against the victim.
Yeah.
The public policy reason, if you want to call it that, for these limitation dates is that the government has decided that people should be able to live without worry of being sued for events that take more than 2 years prior to when they could be discovered. And often a fraudster, especially a sophisticated one, will know this. So they'll just keep trying to string you along, even when it's known that the fraud has been recovered, with promises of payment in the future, with threats like, if you sue me, you'll never see anything. I'm only going to pay people back who don't sue me, that sort of thing.
Right. So there really is no benefit to waiting.
Yes.
So with that, we'll wrap up. Thank you so much, Norm, for your time. And we will be back shortly with another episode.